Good afternoon, everyone. Welcome to day 4, which is the last training session on capital markets. Thank you so much for being with us throughout. And today's topic promises to be very interesting as usual. Today we'll be having 2 topics rolled in one. The first one will be on capital market dispute resolution. In other words, when there are disputes within the capital markets, which courts have jurisdiction and how are they settled? And I also know that people have been asking with respect to how do you join the CMSA? We're going to have a 15-minute session immediately after our first training session, particularly on that, telling you the process to join the CMSA. Then we'll have questions and answers. So we'll jump right into it. I'd like to introduce our speaker, who is Mr. Ikechukwu Albert Ogu. He's a Deputy Director Legal and Assistant Chief Registrar 1 of the Investments and Securities Tribunal, and he's currently the head of the Enugu Zonal Office of the Investments and Securities Tribunal. He has worked with the IST since October 2004 till date, thus has a lot of experience in this regard. And he has written several works on capital markets, arbitration, pension law, and sundry other topics. Please, a round of applause, and I'd like to welcome Mr. Ogu. Thank you so much. Mr. Ogu, over to you.
Thank
you. Okay.
Okay. Good afternoon.
Good afternoon. We can hear you loud and clear.
Okay. Without seeking leave from you, I amended the topic. Instead of capital market dispute resolution, I just amended it to capital market dispute resolution mechanisms in Nigeria. Let's circumscribe it to Nigeria, and the mechanisms are more than one. So these are the amendments I made to the topic. I hope I get a ratification. Now, I presume that we've had the definitions of the capital market in previous topics. So we just leave that and go to a very interesting topic. That is, what are the goods that are traded in the capital market? The goods are securities, and you see the definition of securities under section 315 of ISA. ISA stands for Investments and Securities Act. ISA stands for Investments and Securities Act, number 229 of 2007. So it tells us what securities stand for. So you can see that, interestingly, section 868 of CAMA has a shorter definition of securities, but with the same content. Now, you may, in that definition, you see the concurrent appearance of shares and stocks, which suggests that the two have different meanings, but they don't. They are rather synonymous. And that is what you see from the definition of share under section 868 of CAMA. So now we'll go straight to the issue, that is disputes in the capital market and how they are resolved. As in other areas of human endeavor, disputes do arise in the Nigerian capital market. And luckily, the Investments and Securities Act has made provisions for their resolution. There are two types of, there are two distinct but complementary forms of dispute mechanisms in the capital market. The first one is administrative cum quasi-judicial, while the other is judicial. Now, on the administrative cum quasi-judicial resolution of capital market disputes, you look at the definition of administrative by Black's Law Dictionary, and if you combine it with the provision of section 5, subsection 1A of the Constitution of the Federal Republic of Nigeria, 1999, as amended, you have an idea that it talks about the government agency that is in charge of managing the capital market. You see where I highlighted officers in the public service. This of the expression officers in the public service with regard to the capital market could be referred to as the securities and the management and the staff of the Securities and Exchange Commission, which is the regulator of the Nigerian capital market. So below the administrative and quasi-judicial mechanism in the Nigerian capital market is just about the regulation of the Nigerian capital market. And you see, a minute. Okay. Now, you see item 12 of the exclusive legislative list, part 1, second schedule of the Constitution of the Federal Republic of Nigeria. It talks about capital issues. Now, the law permits a non-judicial body to determine questions arising in the administration of any law affecting the civil rights and obligations of a person, just with the caveat that the person must be given fair hearing and the decision of the non-judicial body must not be final. So you see the authorities there. Now, a minute. Now, if you look at the Investments and Securities Act, now you see that there are under the administrative quasi-judicial resolution of capital market disputes, the two key players in that regard are Securities and Exchange Commission and what we call SROs. SROs are self-regulatory organizations, such as the Nigerian Exchange Group, the Central Securities Clearing System, the FMDQ OTC, that's a financial market dealers quotations over-the-counter securities exchange, Nigeria Commodity Exchange. These are self-regulatory organizations. Now, so in addition to the provisions of ISA relating to dispute resolution in the Nigerian capital market, SEC has also made rules and regulations, including rules relating to the complaints management framework of the Nigerian capital market. In 2015, SEC came up with what it calls complaints management framework of the Nigerian capital market. It was slightly amended in 2019. Now, the rule 2 of that framework mandates SEC and self-regulatory organizations and other capital market operators to come up with impartial, fair, and objective complaints management policies for listed disputes, which include complaints against operators by clients, complaints between operators, complaints against regulators and SROs, that's self-regulatory organizations, complaints against operators by SROs and regulators, trade manipulation, accounting frauds, Ponzi schemes, and such other complaints as may be determined by SEC. Now, we see, just like in the case of share and stock under section 315 of ISA, we also see the concurrent appearance of regulators with small letters, then regulator with a capital R. So in paragraph C and D of Rule 1 of the framework. I am of the humble view that this is deliberate because Section 13 of ISA describes SEC as the apex regulatory organization of the Nigerian capital market, meaning that we have a hierarchy of regulators with SEC at the apex. Now, rules 3 to 10 of the framework, lists contains guidelines and timelines for resolving disputes at every stage of the framework, specifying dispute types appropriate for each stage. Interestingly, Rule 5 talks about complaints lodged with capital market operators and listed public companies. I consider this respectfully as immaterial because these capital market operators, the players and the listed public companies, they hardly redress complaints lodged by aggrieved investors. And that is why many of such complaints go up to SEC and eventually end up at the tribunal. So assuming they do redress such complaints, like in Nigeria, where you complain to your bank and the bank does nothing about that, you end up referring to the CBN. So now let's look at capital market dispute resolution by SROs. SROs are securities exchanges, capital trade points, association of market dealers, clearing houses, etc. You see that definition under section 315 of ISA. Now, they are key players in the Nigerian capital market. One condition precedent for their registration is that their rules must make satisfactory provisions for the discipline of their members and the regulation of the activities of their members. You see that under section 29 of ISA. Now, the essence of their registration requirements, very stiff ones, will be appreciated the more against the background that capital market thrives on trust and investors' confidence. If you remove trust and investors' confidence from the capital market, it collapses. So, and while seeking registration, SROs must submit their rules. It is these rules that they use to discipline and regulate the activities of their members. Now, they have powers to reprimand, expel, suspend, or otherwise discipline their members, subject to review by SEC. You see section 33 and 34 of ISA on that, and you also see the cases referred to. Now, however, if an SRO takes any disciplinary measure against an erring member, it must notify SEC within 7 days. Now, based on the framework for the management complaints management framework arrived at by SEC, or drafted by SEC in 2015, let's look at the type of disputes that SROs can resolve. So now you see complaints by capital market operators, that's CMOs, and public companies. They can be lodged, there are two ways, either by first instance or by reference. Now you see one, complaints between capital market operators. For instance, I talked about a claim for compensation under the Investors Protection Fund being first made to an SRO. That is what that's what the Act provides, and you see that under section 213 of ISA. So now the second one is complaints against SROs themselves. In either case, an SRO has 20 working days to resolve the complaint, failing which it has 5 working days to refer sent to SEC. Now, referrals to there, like I talked about, complaints that can be lodged at first instance, and then you have referrals to SROs. Now, in the referral letter, it must state when you are appealing against a judgment, you compile the record of proceedings. So a letter referring a matter to an SRO must have a sort of record of proceedings, and it must be delivered within 2 working days at the end of the proceedings. That is, it refers to the proceedings before a capital market operator or listed public company. And the SRO has 20 working days to resolve the complaint. If a complainant is dissatisfied with SRO's decision, it may approach SEC within 2 working days of the decision. SROs are required to maintain and update an electronic complaints register containing name of the complainant, date of the complaint, nature of the list is there. So the items to be contained that the complaints register should contain, they are there. Now, we now look at capital market disputes resolvable by the Securities and Exchange Commission. SEC was established under section 11 of ISA. Is the apex regulator of the Nigerian capital market. It is endowed with enormous and far-reaching regulatory functions and powers under section 13A2 GD. You see, when you look at section 13 of ISA and look at the enormous powers the ISA vests on SEC, it's amazing. It's amazing. So SEC is not SEC wouldn't complain of absence of legal empowerment regarding its ability to regulate the Nigerian capital market. it has more than enough powers to do so. Now, and the SEC also, as a corporate entity, as a juristic person, has power to sue and be sued in its corporate name. You see that under Section 1, subsection 2. So then there are other sections referred to. Those sections are also sections where SEC can take a matter and can file a matter before the tribunal. They can only do that if it's a juristic person. Now, interestingly, section 8.2 of CAMA, re-emphasizes the regulatory powers of SEC over the Nigerian capital market. And SEC is the fulcrum of administrative quasi-judicial regulation of the Nigerian capital market because of, one, its enormous regulatory powers under section 13A to DD, and for being in charge of the operation and application of the ISA. If you look at section 13DD and sections 13DD 284 of ISA and section 36 sub 2 of the Constitution of the Federal Republic of Nigeria, you will understand that SEC, as the regulator of the Nigerian capital market, is in charge of the operation and application of the Investments and Securities Act. Now, what complaints can be taken to SEC? One, if you consider section 2841 subsection 1 paragraph A, you will understand that every dispute which is resolvable by SEC must arise from the operation and application of the Investments and Securities Act. Then such disputes could be lodged at first instance with SEC or referred to SEC. That's maybe on appeal. Now, complaints which can be lodged with SEC at first instance. One, complaints against an operator by an SRO stroke regulator. That's a complaint against a capital market operator by a self-regulatory organization or even SEC itself. Then SEC is obliged to acknowledge receipt of this by email within 5 working days. You see Rule 8 sub Rule 2 of the framework. Now, secondly, complaints relating to trade manipulation, accounting frauds, Ponzi schemes, and such other complaints as may be determined by the SEC from time to time. So now, let me take us to Ponzi schemes. You see, several SEC has filed matters before the Investments and Securities Act relating to Ponzi schemes, scam companies, those people, wonder banks who promise mouth-watering rewards and return on investments. So such suits were filed by SEC after investigation sequel to complaints by several aggrieved investors. So that I think this is when such disputes come before SEC, complaints come before SEC, it handles them, and where it can resolve them, it comes to the tribunal. Now, for these complaints, SEC has 10 working days within which to review the complaint to know if it's within its purview or whether it should be taken elsewhere. 10 working days, that's a long time. That's a long period of time. Then SEC is also to investigate and to verify the complainant's claims to know if it falls under its purview. Conclude the investigation within 30 working days. That is more than enough time. Then where the investigation discloses a prima facie case, SEC may refer the matter to ECPC or pass it on to criminal prosecuting authorities if a crime is disclosed. You see Rule 8, sub Rules 3 and 4. Then you compare it to Section 304 of ISA, which mandates SEC to refer any criminality that it uncovers in the course of its investigation to prosecuting authorities. Now, complaints which can be referred to SEC. Now, SEC has 5 working days to review any complaint that is referred to it to know whether it's within its purview or not. If it has jurisdiction over the matter, it shall resolve it within 20 working days or an extended period, it deems proper. Then a complainant who is dissatisfied can approach the Investments and Securities Tribunal. See Rules, Rule 9, sub Rules 2 and 3, then compare with Sections 284, subsection 1A, and 289, subsection 1, subsections 1 to 3 of ISA. So now look at some of the tools that are used by SEC in resolving capital market disputes. The list here is not exhaustive. So if you want to see the entire list, you go to Rule 601 of SEC Rules and Regulations. Especially That's the or
Sorry,
how they carry
Mr.
out the
Ugu.
activity. Hello?
We seem to be losing you in and out, Mr. Ugu. Can you hear us?
Yes.
Okay. If you can start from rule 601, that's where we lost you.
Okay.
Yes, thank you.
I'm coming. (601). Okay.
I think it's the
Okay.
slide you're coming from. It was, yes, we were at the slide where you said to see the full list, go to 601.
Okay.
Yes,
Okay. I
that's the
thought.
last thing you read.
Okay.
Yes.
Okay. I now says I'm talking of the tools used by SEC to resolve capital market disputes. Do you hear me?
Loud and clear.
Okay. Now I said the list of the tools I stated here and is not exhaustive. But if you want to see the exhaustive list, you go to rule 601 of SEC rules and regulations. Now, part of one of the tools SEC uses is issuance of directives to SROs. It does this regarding how trading is carried on their platforms, or how they carry out the activities in respect of any other matter. And an SRO is obliged to comply with such a directive. See section 35, subsection 1A to C of ISA. SEC may also seek enforcement orders from the IST for its directives, especially where an SRO declines to comply with such a directive from SEC. You see section 36 of ISA, sections 114, 116, 303 of ISA. Now, an aggrieved SRO or any other person can challenge SEC's directive before a court or the IST, provided it joins SEC as a party. You see this in section 35, subsection 2 of ISA. I don't understand what the word court is doing there, since IST is a statutory court for capital market disputes. However, the legislature knows best. Now, SEC is also permitted to review, is also empowered to review disciplinary actions taken by SROs against their members. I had referred to section 33, where an SRO is empowered to discipline its members. So SEC is empowered to review such disciplinary action, affirm or set it aside, provided it grants hearing to the affected member and SRO. You see section 34 of ISA. Then rules 202, 226, and 248 of SEC rules. There's also a case studied by AST referred to there. Then SEC can also, where an SRO fails to take disciplinary action against an errant member of his platform, SEC can step in and discipline that errant member directly. So now you see rule 598 of SEC rules. And then I refer to a case here of SEC and Thomas Kingsley, where SEC had to do that. He stepped in and suspended Thomas Kingsley over a capital market misconduct. It can also expel or otherwise discipline such members. So now, interestingly, the Investments and Securities Tribunal has severally upheld SEC's power to discipline erring capital market operators. You see the cases referred to there. These are just a few out of many. So now, in Fort Oil PLC, and Fidelity Finance, the Court of Appeal interpreted SEC's power to sanction capital market operators to include the power to determine when the penalties so imposed have been fulfilled. Now, another tool SEC uses is suspension or prohibition of further trading on securities, where it deems it necessary for the protection of investors in a particular securities offered for trading. SEC can order the suspension or prohibition of such or further trading on such security for a given period, and give written notice to the SRO on whose platform the trading takes place. Now, section 36, subsection 4A to E of ISA. A minute. Okay, prescribes punitive actions which SEC can take against a capital market operator. The lists are many. The list is small. It contains so much. So it includes seeking an order from IEC to enforce its directive. I refer to the relevant sections there. SEC can also suspend an errant individual capital market operator from participating in the market for a given period. You see the cases referred to there. Now, under section 13, subsection IV of ISA, SEC can enter and seal up a premises which is being used to carry out illegal capital market activities. So it has done this a number of times, you know. Imposition of a fine in lieu of prosecution, where SEC considers it expedient, it can impose fine in lieu of, instead of referring an errant capital market operator to prosecuting authorities, SEC may impose a fine, a heavy fine on such an operator, and save government the cost of prosecution. Now, interestingly, Rule 600 of SEC rules has come up with an innovation called negotiated settlement, where an errant capital market operator can approach SEC for a negotiated settlement. Okay, I did this, I am sorry, what can I do? Should I restitute the victim? Should I pay compensation? Should I buy back the shares? Now, this is similar to what we have under section 270 of the Administration of Criminal Justice Act, that's regarding plea bargain. This is a commendable provision by SEC. Now, the reference of criminal matters to prosecuting authorities. SEC is empowered to do this. You see that under section 304 of ISA, and then under Rule 8 of the framework, the tribunal upheld those provisions in the cases cited there. Now, and in a number of cases, SEC has deployed activated the provisions of section 305 by referring errant capital market operators whose misconduct contained criminalities to prosecuting authorities like EFCC, the Attorney General of the Federation, or Attorney General of one state or the other. Now, without prejudice to this SEC's power to refer an unaided criminality to the prosecuting authorities, SEC can also take the errant capital market operator to the tribunal. And so you see section 303, subsection 4. Then there's it happened in the case of Thomas Kingsley Securities, SEC and Thomas Kingsley Securities. There was a criminal aspect, which is a Federal Republic of Nigeria against Sir Kingsley and another. And then the civil aspect was SEC and Thomas Kingsley Securities and another. Then SEC institution of suits at IST against capital market operators who violate the laws, the extant laws. SEC can and has been doing this over time. And now, so you see, I refer to some cases there. One is reported, the other are not reported. Those are decisions of IST in respect of cases where SEC filed suits against capital market operators for one misconduct or the other. Now, restitution. So we know how important restitution is in law. So for instances where capital market, where investors suffered losses or defalcation as a result of the misconduct of capital market operators or SROs, SEC can secure restitution for such victims by ordering compensation or share buyback, or directing compensation to be paid from the Investors Protection Fund, or by seeking enforcement of freezing orders from IST towards the same purpose of restituting an aggrieved investor, or even asking the tribunal to void a transaction which contravenes the law. So I refer to the relevant sections of the law and the applicable cases decided by the IST. Now, interestingly also, in Fort Oil PLC and Fidelity Finance, the Court of Appeal upheld the mandatory nature of Section 13X of ISA. That Section 13X of ISA mandates SEC to seek enforcement orders in order to freeze the accounts of offending capital market operators. So SEC cannot do that without getting cannot freeze the account of a capital market operator without getting the order, the necessary enforcement order from or freezing order from the tribunal. That's what the Court of Appeal has clearly stated in this Fort Oil PLC and Fidelity Finance. Now, in some cases, aggrieved parties have filed appeals or even originating applications challenging the decision reached. Okay, I think I've missed something here. Okay. Now we're talking of methods adopted by SEC in resolving capital market operators. What we've dealt with so far are the tools used by SEC. We are now looking at the methods. One is all parties meeting. All parties meeting, in an all parties meeting, SEC receives a complaint, investigates it. What if it discovers any misconduct there? It invites all the parties to come with the relevant documents. It's just the all parties meeting. The proceedings are guided by documentary evidence, just like you have in originating summons. So the parties bring out the relevant documents, and the documents speak for themselves, as we are, or just like FAST speak for themselves. Now, so the documents are examined, and SEC gives its decision and communicates them to the parties in writing. The decision could be imposition of a penalty, suspension, expulsion, etc., or order of compensation or restitution to the victim, or SEC can convene its APC, the Administrative Proceedings Committee, over the matter for a full hearing of the matter, or it can refer the matter if a crime is discovered in the matter. It can refer it to prosecuting authorities, or it can institute an action against the errant capital market operator before the tribunal. So now, this regarding the reaction of persons to the ATM, that's the all parties APM, all parties meeting. Some of them have, as a result of the decision of SEC, sequel to the all parties meeting, they have filed appeals at the tribunal or even originating applications challenging the decision of SEC through its all parties meeting. So whichever way the matter comes, whether it's originating application or by an appeal, the tribunal does entertain them. Now, so in a nutshell, ATM, the all parties meeting. I wrote all parties meeting instead of I made a mistake. I put ATM. All parties meeting is SEC's informal way of fast-tracking investigations and resolving disputes. You compare this to let's look at Rule 299 of SEC rules. The title is all parties meeting, but it's not all parties meeting regarding the one we're talking about. It relates to all parties meeting that comes along during a public offer, where SEC convenes a meeting of all the players, all the officials who are involved in the public offer. That one is different, but the all parties meeting we're talking about is for a resolution of disputes. Now, then we look at the APC, the Administrative Proceedings Committee of SEC. Section 310, subsection 1 and 2 of ISA empowers SEC to set up committees to which it can delegate any of its functions and to determine the number of their members, the number of members of such committees. Now, no decision of such a committee shall be effectual unless confirmed by SEC. You look at section 310, subsection 3 of ISA. You look at item 2, paragraphs 1 to 4 of the first schedule to SEC. That is the rule guiding the APC of SEC. Now, so above this section 310 is the legal foundation of the establishment of SEC's APC. And also, you see, it is under section under Rule 599 of SEC rules that SEC actually established the APC. So the foundation for the establishment of the APC under Rule 599 is found in section 310 of ISA. So the APC is not different from SEC. So did the tribunal hold in Bogunjoko and another versus SEC. So it's just the major instrument SEC uses in carrying out its quasi-judicial functions. And so you see the relevant cases. The issue of SEC using the APC to carry out its quasi-judicial function takes our mind back to section 36, subsection 2A and B of the Constitution of the Federal Republic of Nigeria, which allows non-judicial bodies to do so, provided they hear the parties involved and their decisions are not final. And so now any party who is aggrieved by SEC's APC decision may appeal against it to the tribunal within 30 days of receipt of a certified copy of the decision. You see section 2891 and 2 and 2841A, paragraph A, I to IV of ISA. Now, there's a very interesting thing which the tribunal has abated or has taken care of. Section 13, paragraph U of ISA and Rule 12 of APC rules, that's Administrative Proceedings Committee rules, empower SEC to levy penalties, fees, penalties, and administrative costs for the conduct of its APC. Now, and SEC has been doing this. However, the tribunal in a long line of cases has set aside the costs. In most cases, SEC awarded costs to itself after its APC proceedings. But the tribunal in a number of cases, some of which are listed, set the award of costs by SEC to itself aside, saying that SEC is an administrative body carrying out its official duties, and government it has budget for that, government funds it, so it shouldn't be awarding costs to itself. So that is the position currently, unless maybe in some cases SEC does so and the parties don't complain. But whenever they complain to IST will set that cost aside. It's just like a court awarding costs in favor of itself. And so now the other issue, the other way SEC resolves capital market disputes by filing suits at the IST. We've seen this. Order 10 of IST Procedural Rules 2022 made provision for the receipt of such suits filed by SEC. Now, we look at judicial resolution of capital market disputes in Nigeria. This is where my organization comes to play, Investments and Securities Tribunal. Gentlemen, I divided the issue of judicial institution of capital market disputes into two eras. The era before the establishment of the Investments and Securities Tribunal in 2002 December, and thereafter. Now, before the Investments and Securities Tribunal was initially established by Section 234 of the Investments and Securities Act number 45 of 1999, which was repealed by the current Investments and Securities Act number 29 of 2007. Currently, IST's establishment is found under Section 274 of the extant law, ISA, number 29 of 2007. Now, before the establishment of IST, capital market matters, both civil and criminal, were handled by the high courts. Initially, high courts of the regions and states, and then from 1973 to 2002 by the Federal High Court. During the pre-IST era, now capital market matters dragged in court, and capital market matters are at times very time sensitive. Now, so the dragging is it? Okay, I just read something this morning where Honorable Justice John Soho, or the Chief Judge of the Federal High Court, was talking about the Federal High Court having 140-something thousand pending cases before it. This gives you an idea of how clogged, how busy, how clogged the cost list of the conventional costs are. So now, the dragging of the delay in the adjudication of capital market disputes before the establishment of IST affected or impacted negatively on investors' confidence, the attraction and retention of investors, and the growth of the market. So what happened? People complained, investors complained, players complained, and the federal government set up the Chief Dennis Odife panel in 1995 to review the Nigerian capital market. the panel, one of the recommendations of the panel was that a fast-track court should be set up for the Nigerian capital market. That gave birth to IST. So the Minister of Finance then in December 19, 2002, established constituted the tribunal. And since then, the tribunal has been operating, except when it had a sort of, when it didn't have members for like 2 years, between 2015 and 2017. Now, so the IST is a specialized court with exclusive jurisdiction to adjudicate capital market civil disputes in Nigeria. You see Section 284, Section 290 of the ISA. Then this the exclusive jurisdiction of the Investments and Securities Tribunal over civil disputes, capital market disputes, has been given judicial apex judicial affirmation by the Nigerian Supreme Court in the case of Ajayi and SEC. 2023, 6 Nigerian weekly law reports. Well, it's there, you see it. So again, the ISC specialist nature has received the Court of Appeals endorsement, See Wealth Zone Limited and SEC, 2016 decision of the Court of Appeal. If you, okay, we'll see the composition of ISC. This will give you an idea of why it is called a specialist court. You know. Now, look at the composition of ISC. It has 10 members, appointed by the Minister of Finance, one of whom shall be the chairman, who shall be a legal practitioner of not less than 15 years, with cognizant experience in capital market matters. Then 4 other full-time members, 3 of whom shall be legal practitioners of not less than 10 years experience. Then 1 person who shall be knowledgeable in capital market matters. And then 5 other part-time members who shall be persons of proven integrity and experience in corporate and capital market matters. The emphasis is capital market matters, expertise, experience. So you see Section 275, 1 and 2 of ISA. So this gives you an idea of ISC specialist quality. And so now the chairman is the chief executive and accounting officer of ISC, responsible for its overall control, supervision, and administration. Currently, our chairman is not only a seasoned lawyer. Our current chairman is not only a seasoned lawyer, but he rose to the position of a director in SEC. So he is vast both in regulation of the Nigerian capital market and with his experience as a practicing lawyer. He practiced law for over maybe 20 years before. He is also at home with the judicial aspect of capital market regulation. Now, ISC sits in panels considered by the chairman whenever he deems necessary, and the sitting of any panel of ISC is considered the sitting of the tribunal, provided that each panel must be headed by a member who is a lawyer. So, and the quorum of ISC is 3. So you see Section 276 of ISA. Then you compare this with Section 8 of the Interpretation Act, where it prescribes a quorum of 2 for tribunals. I think that provision relates to instances where the enabling law of a tribunal doesn't make any provision for its quorum. I think, and it was this section of the Interpretation Act that was used by the Code of Conduct Tribunal when it had only 2 members to uphold the sitting by only 2 out of the 3 members of the tribunal. Now look at ISC's jurisdiction. To exclusively adjudicate capital market civil disputes in Nigeria, the enabling, you see, so most people think that the jurisdiction of IST is found only in Section 284 of ISA. That is a runaway view of the position. That is with due respect, is uninformed. If you look at sections 13X, 35(2), 36(4)E, 85, 90, 94, 114, 116, 1 and 2. There are so many sections of ISA where you see a reference to the Investments and Securities Tribunal. So for one to appreciate the jurisdiction of the IST, you have to make a combined reading of these provisions along and that of 284, which is the principal provision. Now, Section 284, I reproduced the provision of Section 284 on what makes up the jurisdiction of IST. I want to observe that if you compare this section with this similar section in the repealed ISA of 1999, you see that ISC's jurisdiction under the repealed ISA 1999 is more robust compared to what we have here now, which is more like this one is whittled down, so to say. Well, the legislature knows why they did that. Now, beyond Section 284 of ISA, the Section 294 of ISA, there's a mistake there. Instead of ISA, I put ISS. So Section 294 of ISA re-emphasizes the exclusive jurisdiction of ISC over capital market matters. When it provided that, a minute, so I'm having, maybe because I'm an old man, I'm having some of us were born. Okay, so the tribunal shall have exclusive jurisdiction on matters specified in this act. This is an emphatic provision which reinforces this provision of Section 284. Now, there's an unreported decision of IST, SEC, and Afrobank PLC and 38 others where this reference was made to this section. So, and interestingly, IST is a court for civil purposes. You see Section 290, subsection 3 of ISA. And the IST has also restated its civil jurisdiction in a number of cases. I think the rationale for making IST a civil court is because of we know how the prosecution of criminal matters, how they go in our courts. So, for instance, now if there's if a defendant's an accused person's no case submission is overruled by the trial court, he can go on appeal, and the appeal could take him. He could take it up to the Supreme Court. So I think the legislature was mindful of the delay that is inherent in criminal prosecution, that which made them to exempt IST from handling that. So it is handled by the Federal High Court and the state high courts. All criminal matters arising from the capital market. You look at Section 304 of ISA. Now, there have been controversies over the constitutionality and jurisdiction of IST. Some lawyers have questioned the constitutionality of IST because it is not specifically mentioned under Section 6, subsections 3 and 5, paragraphs, under subsection 5, paragraphs A to I of the Constitution of the Federal Republic of Nigeria. Now, they dismiss the implied reference to IST, which we see under Section 6, subsection 4, A and B, and subsection 5J. To them, it doesn't matter. Now, but interestingly, you see that Section 6, subsection 5J of the Constitution of the Federal Republic of Nigeria refers by necessary implication to the courts which the preceding subsection 4 empowers the National Assembly with unlimited power to establish. So, now, furthermore, Section 246, subsection 2 of the Constitution of the Federal Republic of Nigeria empowers the National Assembly to confer jurisdiction upon the Court of Appeal to hear appeals from the decision of any other court of law or tribunal established by the National Assembly. Interestingly, Section 295 of ISA provides that appeals against ISC's decisions shall go to the Court of Appeal. Now, so, and you also, when you also look at the definition of the use of the expressions any court or other tribunal in Section 36 of the 1999 Constitution regarding fair hearing, you will now understand that the court or tribunal, court and tribunal are synonyms. Now, my humble view is this: the constitutionality of ISC can only be successfully debunked if we can abrogate the unlimited constitutional powers of the National Assembly to establish other courts outside the one specified in the Constitution, under Section 6, subsection 5A to I. If we can do that, then ISC, we can now say that ISC is illegal, it's unconstitutional, there is establishment. Again, we all know that the law does not refer to a subject matter expressly always. There are also, in some cases, there are implied references. Are we doing away with that? So we should reckon with that regarding the implied reference to IST in section 6 of the 1999 Constitution. So this is my humble view on that. Now, well, the constitutionality of IST has received appellate judicial affirmation by the Court of Appeal and the Supreme Court in Wealth Zone and SEC, and then Nospeco Oil and Gas Limited and Olorum Nimbe, and 15 others. The citation is there. So in the first case, Wealth Zone, the Court of Appeal agreed that the IST's it upheld IST's constitutional foundation. The same thing the Supreme Court did in Nospeco's case. Now, furthermore, some other lawyers have also challenged the constitutionality of IST's exclusive jurisdiction based on a perceived conflict between IST's jurisdiction under the ISA and that of the Federal High Court under Section 251, subsection 1E of the Constitution of the Federal Republic of Nigeria. My humble view, respectfully, is that there's no conflict. One, IST's jurisdiction is over capital market civil matters, while the criminal matters are handled by the Federal High Court and the State High Court. You see sections 304 and 305 of ISA. Now, secondly, there is no express reference to capital market matters under Section 251, subsection 1E of the 1999 Constitution. Interestingly, let's take this in further. If you go to item 12, under the exclusive legislative list of the 1999 Constitution, you will see the expression capital issues. Gentlemen, if you go through the gamut of Section 251 of the 1999 Constitution, you will not see any reference to capital market or capital issues. I think the silence of Section 251, subsection 1E of the 1999 Constitution regarding capital market, its silence on capital market matters is deliberate. Then we also talk of we apply here the Latin maxim expressio unius ex exclusio alterius. So now, however, the Supreme Court has in SEC and Ajayi upheld ISC's exclusive jurisdiction over capital market civil disputes in Nigeria. Gentlemen, we were taught by Justice Oliver Wendell Holmes and the other members of the American Realist School of Legal Thought that the law is what the courts say. The Supreme Court has said that ISC's jurisdiction, ISC has exclusive jurisdiction over capital market civil disputes in Nigeria. So there's no, that one is settled. Now, from my own angle, I wouldn't want lawyers to continue talking about whether ISC has exclusive jurisdiction over capital market matters or not, whether its jurisdiction is an affront on that of the Federal High Court. No, see, I want the Federal High Court and ISC to embrace the Igbo philosophy of Egbe Bere Ugo Bere. Let the ego and the kite perch concurrently, simultaneously. And then there's also the admonition by the former Roman emperor, Marcus Aurelius, in his book, Meditations. He said, let us stop talking about who a good man is. Let's start being one. So let the two courts continue with their matters. Let's forget which one is superior, which one is not, and which one encroaches on the other. Let whatever matters that are filed before the Federal High Court, which is covered by Section 251 E, let the Federal High Court attend to it. Whatever matters that are filed before the Investments and Securities Tribunal, which are covered by the provisions of the ISA, let the IC handle them. So that is my humble view on that. Now, regarding the practice and procedure of the IST, IST was set up to deliver expeditious dispute resolution of capital market disputes in Nigeria, and thereby restore and sustain investors' confidence. If you look at the provision of section 289, subsection 5 of ISA, now you will see it clearly codifies the need for IST to be expeditious in its adjudicatory functions. It states, the tribunal shall, in the exercise of its powers under this act, conduct its proceedings in such a way as to avoid undue delays and shall dispose of any matter before it finally within 3 months from the commencement of the hearing of the substantive action. So now, I want us to understand something about this matter. This particular provision now came as a result of a sort of judicial amendment of the repealed ISA 1999. In the case of Unilever Nigeria PLC versus ISS Limited, it seems I didn't put it right. So IST had modified the initial provision, which talked about 3 months starting from when the matter was filed. So now IST had heard that it doesn't make sense. So the legislature, in amending that ISA, now reflected the judicial amendments introduced by IST in Unilever PLC, Nigeria PLC versus ISSL Limited. So now, in order to achieve its mandate for expeditious adjudication, IST adopts a flexible dispute resolution mechanism that is devoid of insistence and reliance on technicalities, and the foundation for that is found in its robust overriding objective found in Order 2, Rules 1 and 2. Is in the I deleted it. I didn't put better. Maybe I don't know. I think I still have time. So now let me read the. But what, gentlemen, you need to get a copy of IST Procedural Rules 2022 to see the overriding objective of the rules. But however, let me read it. Now, Rule 2, Sub-Rule 1, Paragraph 1 says, the overriding objective of these rules is to enable the tribunal, with the assistance of the parties, deal with cases fairly and justly. Then, Sub-Rule 2, dealing with cases fairly and justly includes A, providing a reliable, informed, expedient, flexible, and affordable dispute settlement mechanism for investors, public companies, capital market operators, self-regulatory organizations, and other market participants. B, promoting capital market integrity and stable economy. C, dealing with cases in ways which are proportionate to the complexity of the issues and the resources of the parties. D, ensuring so far as practicable that the parties are on an equal footing procedurally, including assisting an unrepresented party in the presentation of his or her case without advocating the course he or she should take. E, using the tribunal's special expertise effectively. I have told you from the composition of the tribunal, you see that the law requires the appointment of specialists as its members. Now, F, avoiding delay so far as compatible with the proper consideration of the issues. Then, Sub-Rule 2.1, the tribunal shall seek to give effect to the overriding objective when it A, exercises any power under these rules, or B, interprets any rule. Then Sub-Rule 2, in particular, the tribunal shall manage cases actively in accordance with the overriding objective. So that's the overriding objective of the tribunal's rules. Now, the further speedy adjudication of civil disputes in the capital market, IST rules provide for front loading of documents in its proceedings, in IST proceedings. You see Order 14, Rule 2 of IST procedural rules. See, gentlemen, I must tell you, IST is the first court in Nigeria to provide for front loading of documents in proceedings. You see that in IST procedural rules 2003, which that's the first procedural rules of IST. You see it there. Before any other court, I'm boldly stating that other courts borrowed a leaf from IST. So we can nod our heads like it's the lizard that fell from the iroko tree. Now, Section 290, subsection 2 of ISA confers on the tribunal enormous judicial powers for the control of proceedings before it. Those powers are the inherent powers of any court. Then by Section 291, a party can appear in person or engage a legal practitioner to represent him before IST. Then let's look at the modes of instituting cases before the IST. IST has both original and appellate jurisdiction. See the sections cited there, the mini sections. They refer to either somebody filing a matter before IST or maybe coming on appeal. So then matters can be instituted by A, originating application, and by notice of appeal. See Section 289. ISA. See, I want to say something about originating application. If you get a copy of IST rules and look at the schedule, the precedent originating application form, you see that it is an amalgam of a writ of summons and originating summons, which we see in the conventional courts. So the two forms were merged, and then IST came up with originating application. So that is why, even if what you are bringing before the IST is merely documentary, which in the conventional course will require you to go by way of originating summons, or it's not, it requires, it involves a lot of verbal evidence, you still come by originating application. So now, the rules of IST contain elaborate provisions for the filing of originating applications and appeals before IST. You see rules 4, 5, 8 to 10 of the rules. Now, when we are talking of appeals here, we're talking of appeals against the quasi-judicial decisions of SEC. You see section 284 and 289, 1 to 4 of ISA. Because SEC is the apex regulator of the Nigerian market. And in that capacity, it carries out quasi-judicial, it delivers quasi-judicial decisions. Now, whether it is there's an interesting provision which we find under the proviso to section 2891 of ISA. Whether you're coming by way of originating application, whether it's against the action or inaction of SEC. Interestingly, in the case of Ubuke versus Value Line Securities and Investment Limited, the tribunal interpreted SEC's inaction, SEC's delay in handling a complaint as amounting to an action, which now warranted the aggrieved investor to approach the tribunal directly. So whether you are filing an originating application before IC or you are coming by way of appeal, the Act requires you to give a 14-day pre-action notice. This is a condition precedent. Now, my humble view is this: there should not be a pre-action notice in case of appeals, because already under the section 289 3 or so, a party who is appealing, a party has 30 days within which to file appeal. And we know that in filing appeals, when you file a notice and grants of appeal, you serve the other party. So I don't see why the pre-action notice here should apply to appeals against SEC's decision. If you are talking of action, that's a originating application, we understand that, but appeals, no, because the matter had been handled by SEC, and SEC is aware that one of the parties is aggrieved and may go on appeal. So what other notice does SEC require? This provision, which applies pre-action notice to appeals, I don't think it applies. It is seen in other provisions of other relating to other regulatory bodies in Nigeria over the people who are suing them. Now we go to the enforcement of IST judgments. IST is required by section 2931 and 2 of ISA to deliver written judgments and make certified true copies available to the parties upon their request. Now, however, section 293 sub 3 says that IST's judgments shall be enforced as if they are judgments of the Federal High Court and shall be registered by the IST with the Chief Registrar of the Federal High Court. Now, respectfully, I do not see the need for this provision. IST should be allowed to enforce its judgments. So this circuitous mode of enforcement of IST judgments with its associated bureaucratic delay hampers speedy resolution of capital market disputes. Imagine where IST delivers judgment in a matter within the prescribed time of 3 months, and for one reason or the other, the judgment creditor encounters bottlenecks in his effort to levy execution. The blame wouldn't be on IST anymore. So IST should be, the legislature should, at the earliest opportunity, amend this provision and empower IST to enforce its judgments. That's my humble view. Now, appeals against IST's decision, they go to the Court of Appeal. Now, the provision is that, you see section 2951, the provision is that if the decision was given in the exercise of ICC's appellate jurisdiction, that's regarding appeals against decisions of SEC, or it is an interlocutory decision. Okay, no, if it was given in the exercise of ICC's appellate jurisdiction, then the appeals have to be on points of law only. However, if the decision was a final decision of ICC in the exercise of its original jurisdiction, the appeals will be on points of law or mixed law and fact. But for interlocutory decisions, it has to be on points of law. Now, there's an interesting provision, section 295, subsection 2 of ISA, which says that it's only parties who participated in the proceedings of the tribunal that can appeal against its decision. Respectfully, I feel that this provision flies in the face of what we know in law, especially if you look at sections 243, paragraph A, section 244, sub 2A, section 245, sub 2A, and then section 246, sub 2 of the Constitution of the Federal Republic of Nigeria. What I was taught and what I see in these provisions in the Constitution is that an person having an interest in the matter can, with leave of court, appeal against a judgment, even when he did not participate in the trial leading to that judgment. So I urge the National Assembly to, at the earliest opportunity, amend this so that interested parties, persons with interest in a matter, in a judgment given by ISC, can appeal against them. So now, section 297 empowers a party that is dissatisfied with the judgment of the Court of Appeal to approach the Supreme Court. Now, let's look at the contributions of IST to the Nigerian capital market. The list here is not exhaustive. If I talk if I decide to write about the IST's contributions to the Nigerian capital market, maybe I may end up writing a PhD thesis. Now, first of all, judicial regulation of the Nigerian capital market. By determining questions of law or dispute arising in the Nigerian capital market, by interpreting applicable laws, rules, and regulations, and by its judicial review of the actions and quasi-judicial decisions of SEC, the IST is involved in the regulation of the Nigerian capital market. We see Lord Denning's dictum in Parker and Parker. Then we also see the view of the sociological school of law, which says that the law is what the courts say. Like now, the provision of ISA, which empowers SEC to award costs in favor of itself over its APC proceedings, the tribunal has nullified that by its decision. So that is now that's an aspect of judicial regulation. I will also show you people other instances of judicial regulation as we go down. Now, another contribution of IST is that IST has also endorsed SEC actions and decisions, provided they are sanctioned by the provisions of ISA and SEC rules. So by this, IST has enabled SEC to carry out its duties as the regulator of the Nigerian capital market. I refer to some cases that were decided where IST upheld SEC's actions and decisions. Now, IST has also boosted the international recognition given to the Nigerian capital market. IST is the first of its kind in Africa and has received global accolades thereof. Interestingly, in 2006, Nigerian Securities and Exchange Commission, was admitted as Appendix A signatory to the multilateral memorandum of understanding of the International Organization of Securities Commissions, IOSCO. Part of the reasons given for admitting SEC into that body was because of the establishment of IST as the judicial body of the Nigerian capital market. Now, like I told you, IST was set up to render expeditious adjudication of capital market disputes and thereby restore investors' confidence in the Nigerian capital market. Because capital market matters are time sensitive, investors become wary of jurisdictions where such disputes are delayed. So, but since IST came in, IST has restored investors' confidence. somebody may say, what of the downturn in the capital market? IST is not to blame for that. We know of the meltdown which started in 2008. But for IST, it has been doing it has been playing its role effectively. Now, so IST's decisions has helped to restore and boost investors' confidence in the Nigerian capital market and resulted in increased market capitalization. Now, there was this study which was published somewhere. I didn't put it in the slide, but it said that from 2003, when IST started up its adjudicative functions, to 2021, IST gave judgments worth over 868 billion naira in monetary value. This is humongous. Now, activation of the Investors Protection Fund. If you look at sections 197 to 221 of ISA, it provides for the establishment and management of an Investors Protection Fund for the compensation of investors who suffer pecuniary losses as a result of the insolvency, bankruptcy, negligence, or defalcation by members of a securities exchange or capital trade point. Now, I refer to the case of both Nigeria Limited and Nigerian Stock Exchange, where IST held that the IPF, Investors Protection Fund, is a safeguard against unauthorized and unwarranted dealings in investors' funds. Now, interestingly, this Investors Protection Fund has been there with the huge sum of money it has generated lying dormant in an escrow account. It was only in 2006. Then it didn't even have rules for its management and application. It was only in 2006 that IST activated that Investors Protection Fund through its case of its decision in Livinus, Ezebebe, and Nigerian Stock Exchange and another. Immediately that decision was given, SEC and the Nigerian Exchange Group, which was formerly Nigerian Stock Exchange, drafted rules to regulate the application of the Investors Protection Fund in deserving cases. Now, in some cases, like both Nigeria Limited and Nigerian Stock Exchange and OWO, and OWO and then OWO and Apex Securities Limited, the proceeds from the Investors Protection Fund were sequel to ISC's decisions applied to compensate aggrieved investors. Then this issue of institutionalization of the know your customer rule in the Nigerian capital market. Before ISC's decision in Motin Trust Limited and SEC, there was no provision in SEC rules or ISA on the importance of the know your customer rule. But IST harped on the importance of KYC rule in that decision. Consequently, SEC made Rule 347 of SEC rules, where it mandated capital market operators, SROs, and capital market participants to abide by the anti-money laundering and combating financing of terrorism regulations for capital market operators, which we see in Schedule 11 to SEC rules. So it's a very expansive regulation, which lays emphasis on know your customer rule. So we commend IST for kindling the need for know your customer rule in the Motin Trust case. Now, elimination of bottlenecks in the adjudication of the speedy resolution of capital market disputes. IST has, one, through its flexible civil procedure rules and decisions, eliminated some bottlenecks which delay the speedy resolution of disputes. Now, for instance, to avoid undue delay in SEC's handling of investors' complaints, IST in the case of Ubuke and Value Line Securities Limited interpreted SEC's inaction. Somebody, an aggrieved investor, complained to SEC, and for up to 8 months, SEC did not know over that complaint. So IST interpreted that inaction as amounting to an action, which now justified that aggrieved investor to come straight to IST. So this decision has improved the timely resolution of capital market disputes in Nigeria. Tackling Ponzi schemes. and Wonder Banks. In so many cases, I listed them there. SEC filed a suit before IEC against several Ponzi schemers, owners of scam companies, and promoters of Wonder Banks. So it filed suits before IEC against them, and IEC gave orders freezing the bank accounts of those Ponzi schemes and ordering monies found therein to be paid to the defrauded investors. Now, tracing process of sale of closed shares and restricting the investors. In 2002, there arose a series of cases which we call the Bunkolans cases. Now, they are listed there. They have over 200 stockbroking firms cloned the shares of many investors and sold them. So in the resulting cases, the Bunkolans cases, IEC traced the process of the sale of those loan shares and ordered the restriction of the defrauded investors. We as lawyers know about the principle of tracing in redeploy. So IEC deployed that principle in tracing those funds and ordering their use in the compensation of or restriction of the aggrieved investors. So now, reducing the cost of litigation also in the capital market. I talked about section 13U of ISA, which empowers SEC to charge fees, levies, and administrative costs in these activities. And SEC now utilize that provision to award costs in favor of itself or to itself in after each APC proceeding. So in the cases I listed there, tribunal said, no, SEC, you are not being a regulator carrying out a statutory function and being fully funded by government. You are not. It doesn't lie in your mouth to demand the cost from parties who appeared before your APC. So the tribunal set aside such award of cost by SEC, and by so doing, the tribunal has reduced the cost of litigation for capital market litigants. Now, in 2014, the federal government, the federal government has acknowledged the importance of IST to the Nigerian economy, and this it did when, in a white paper, it adopted the recommendation of the Steve Orosanya Committee on the Rationalization of Federal Government Agencies, said that IST is relevant to the economy and should be sustained as it is and fully funded. Now, I refer to the framework SEC drafted for the resolution of disputes in the Nigerian capital market. I have some critique of that framework. Now, first of all, the complaints in Rule 2, paragraph C to E of the framework do not align with the provisions of Section 2841 C to F of ISA. 2841 C to F is where the main provision on ISC's jurisdiction. Now, the handling by SEC and SROs of complaints in Rule 2C and D of the framework conflict with Section 36(1) of the Constitution of the Federal Republic of Nigeria and the principle of nemo est judice in causa sua. See, we should know that objections to SEC being the complainant, prosecutor, and judge partly informed the establishment of IST. And in 2012, interestingly, in 2012, similar complaints trailed some of the cases SEC sought to handle via APC. And because of that, SEC now had to file those matters before IST. So the provisions of Rule 2, paragraphs C and D of the framework seem to restore this practice of SEC being a judge in his own cause. SEC and SROs being judges in their own cause. Now, the proposed framework seems to violate the provisions of sections. I listed the sections which talked about capital market, SEC and other aggrieved investors approaching the tribunal directly over whatever complaint they have. So now, again, so in a way, the framework flies in the face of the rationale for the establishment of IST. coming. The proposal also differs from the provisions of sections 33 and 34 of ISA on disciplinary actions to be meted out on capital market operators. Section 33 of ISA talks about SROs disciplining their members. And then section 34 talks about SEC reviewing such disciplinary actions. So this proposal seems to conflict with the proposal in the framework seems to conflict with those provisions. Now, the proposal also violates section 36(2) of the Constitution of the Federal Republic of Nigeria by delaying the time within which complainants can approach SEC for hearing at its APC. Now, you also see section 13X that which provides that SEC needs an order of court, an order from the tribunal before it can freeze the account of unregistered operators of unregistered capital market operators. Now, the Court of Appeal had in Fort Oil had upheld the imperative nature of that provision. That's section 13X. So now it must be noted that that framework has created many layers of dispute resolution, and this will heighten delay in the resolution of the time-sensitive capital market disputes. You see some of them saying that SEC has 30 working days, SROs have 20 working days. Now, imagine where, then the capital market operators, 10 working days, SROs 20 working days, SEC 30 working days. Now, you now add that to the 3 months that the tribunal is required, within the tribunal is required to dispose of a matter filed before it. So in a way, respectfully, I'm saying that by so doing, the framework restricts litigants' access to justice, contrary to Goal 16 of UN Sustainable Development Goals. And finally, experience has shown that SEC delays in handling complaints filed before it by aggrieved litigants and investors. We see the case of Obuke. We hope that SEC has improved. So, in conclusion, gentlemen, the speedy resolution of capital market disputes in Nigeria is an imperative for the attraction, retention, and sustenance of investors' confidence in the Nigerian capital market. Again, for effective and efficient dispute resolution of disputes arising in the Nigerian capital market, the players, self-regulatory organizations, the regulator, SEC, and the court, ISC, must work as a team and in sync. Thank you very much.
Thank you so much, Mr. Ogu. We have a couple of questions, but I will just quickly take the presentation on how to join the CMSA, then we'll jump to the questions.
You're welcome.
Okay, so this gives a snapshot of steps you need to take towards joining the CMSA. Now, the first thing you must do is that you must apply to the Securities and Exchange Commission, and this presentation has the details of all of that as we go forward. Once the application is submitted and they confirm that all the documents are in place, SEC will inspect your place of work to confirm that you have a physical address. Once that is sorted, you will have to go through a compulsory training at the Nigerian Capital Market Institute. Now, that institute prepares you for the SEC exam, which you must take and pass. And I believe that the pass mark is 70%. And once SEC confirms that you have passed the exam, then you go for a physical interview at the SEC headquarters. And where you're successful, at that point in time, you are allowed to register with SEC and mandated to now apply to the CMSA to become a member of the SRO. So the issue is, why register with SEC? Now, section 38 clearly states that no person in Nigeria shall operate in the Nigerian capital market as an expert or professional or in any other capacity that has been determined by the Commission, or carry out investments and securities business unless that person is registered in accordance with the ISA and the rules and regulations made hereunder. 315 goes further to define who a capital market operator is as one who is duly registered with SEC. Now, pursuant to section 313 of the ISA 2007, SEC is empowered to make rules and regulations and has done that, foremost of which is the Securities and Exchange Commission Rules and Regulations of 2013. You can find a copy of this on the SEC's website. Now, Rule 178 clearly mandates that any legal practitioner whose opinion will impact directly on capital markets transactions is subject to registration by the Commission. And the functions as expected are clearly defined or clearly stated in Rule 180. So these are the functions that if you are going to perform within the capital market, you must be registered first and foremost with SEC. So it says where you're reviewing statutory corporate documents of an issuer or other transaction parties to ensure that they have the necessary legal capacity and authority to enter the transaction, where you're carrying out due diligence to ensure that all information material to a transaction are disclosed in the documents, where you're advising on legal structure, where you're negotiating, drafting, or reviewing of prospectus, scheme documents, or other transaction documents, where you're advising parties on disclosure obligations and observance of certain compliance within the rules and regulations of SEC or the ISA as they relate to particular transactions, and everything that is listed there from 6 to 9. And any other role that is ancillary to the above shows that you're performing roles or functions within the capital markets, and as such, it would require registration. Now, what are documents that are required for you to register with SEC? Like we said, the first thing is an application. And I'll be the first to confess that the requirements are quite onerous and is in two ways. You will fill a form as a law firm, and that law firm must have at least three sponsored individuals, one of which must be must be a compliance officer. So the firm in the form will fill what is called a Form SEC 3, which can be found on the SEC website, and would have accompanied to it your certificate of registration with the CAC, evidence of payment. If you're a sole proprietorship, it's 500,000, and if you're a partnership, it's 1 million naira. Evidence of payment of a processing fee as will be prescribed by SEC. Your firm profile, which is not limited to a brief history, but your organizational structure, principal officers, details of past and current activities. Where it's a partnership, a copy of the partnership deed. Then there has to be a sworn undertaking to keep proper records and render returns as been specified by the Commission. Also, evidence of net worth for partnership, at least 2 million naira, and for individuals, 500,000. And in this case, your bank statements will suffice. Also, it's one undertaking to abide by SEC rules, which will be placed on the firm's letterhead and notarized. Also, you must have in place a professional indemnity of at least 20% of 2 million naira. In other words, you must have indemnity that if anything arises from any negligence of the firm, you have an insurance that can cater for that. Now, we have just dealt with the firm requirements. Now, for the sponsored individuals, it must be a minimum of 3. And as I said, one must be a compliance officer. Evidence that these individuals have been paying their annual practicing fees. Their full postal and electronic address of their immediate past employers. 2 nominated referees. So first of all, is that you must provide the address of the past employers of these individuals. Secondly, 2 referees that SEC will write to asking to attest to your good character. And the bankers with the current account numbers and the BVN. Also, you must have a detailed CV for each of these individuals. The CV must clearly show the school they went to when they graduated, employment history. Importantly, you must ensure that there's no gap in the year. So even if you are not doing anything or you didn't have a job, you must account for that year by clearly specifying that. Also, police clearance reports for each of the sponsored individuals and 3 passport photographs. Also, some kind of evidence that you have been practicing in a firm or you have at least 4 years post-call experience in capital markets law or compliance work. Evidence of identification, either your passport or utility bill, then copies of all your credentials. SEC would require the original foresighting. Now, once you complete the application and it's submitted, and SEC confirms that everything is in place, they will arrange an inspection to your firm. Thereafter, the individuals will undergo a training session at the Nigerian Capital Market Institute. This training is meant to prepare you for the pre-registration examination, which is a curriculum designed to take you through the full gamut of the capital markets and also prepare you for your role and the things you need to note as you enter into the capital markets. Now, I believe that the pass mark is 70%. In other words, you must get at least 70% for you to have said you have passed the pre-registration examination. Now, if you don't pass this, you can't move on to the next stage. So everyone must pass this before they move on to the next stage. Now, once you pass, SEC will now invite you for what is called a registration interview. At this interview, the principal partner or managing partner must be the person who will present the sponsored individuals. Now, where this does not, where the principal partner MP is not there, you will not be attended to. Like was said in the previous paper, this is a trust business, and SEC, as its own way of doing a due diligence, wants to know who are the people in this company, who is vouching for you, and who will present you at this registration interview. Now, at this interview, you will be meeting with the top echelon of SEC, which would include the DG of SEC and other executive commissioners, and they will also pose questions at this interview just to test your veracity and capacity with respect to capital markets. And where you are successful, you are now issued with a letter that approves, or mandates or shows that you are now registered as a capital market operator with SEC. Now, in that letter, a clause will be there that will mandate you to now register with the Capital Markets Solicitors Association within 3 months and now revert back with evidence to SEC. So by virtue of Rule 25, sub Rule 1, every person registered to perform any function in the market shall be a member of an SRO or a trade association relevant to its function. With respect to lawyers, the SRO is the Capital Market Solicitors Association, which is a self-regulatory association of solicitors and commercial law firms engaged in commercial market practice, capital market practice. Now, the CMSA is only open to law firms and lawyers within that law firm who are sponsored individuals, or lawyers who work with capital market operators but are also sponsored individuals. So not only lawyers in law firms, but also lawyers who are in employment with capital markets operators, for example, issuing houses. Now, once you have that mandate to come and register with the CMSA, you send an application letter to the CMSA, which is accompanied with a membership form. That form will get all the required information as it relates to the sponsored individuals. You would have to show evidence of payment of the admission fee, which is 150,000 naira now, with a one-time fee, and also the annual dues, which is 50,000 naira, making it 200,000 naira. Also, you will need to show evidence that you have been registered with SEC, which is that letter SEC will give you confirming that you've been registered. Without that letter, you cannot be registered with the CMSA. We'll also need to cite your certificate of registration as a firm with CAC, and also evidence of your current bar practicing fee of all the sponsored individuals. Once we get this, the ESCO will sit, consider, and once it confirms that all the required information or documents are complete, the application will be successful and you'll be issued a letter indicating that you are now a member of the CMSA. You'll also be given a copy of the constitution of the CMSA and added to the relevant WhatsApp groups and put on the mailing list and then you can participate in all activities as relates to the CMSA. You'll also write back to SEC indicating that you have now been registered and attach that letter as evidence. Thank you so much, everyone. And we will now just quickly proceed to the questions. And I hope Mr. Ogo is ready to take this question. And I'll read them out as they were written. Mr. Ogo, are you there?
Yes, I am.
Okay, so the first question is, can any lawyer file a matter and appear before the IST on behalf of a client, or does he have to be registered first with SEC as a CMO?
For a lawyer, thank you so much. For a lawyer to appear before the Investments and Securities Tribunal, he or she doesn't need any registration with SEC as a capital market operator. He doesn't appear before the tribunal as a capital market operator, but as a lawyer. And the ISA provides for that a party can appear for himself or engage a lawyer. So that's it.
Thank you so much. Okay, the next question I think you've answered, but maybe just to reiterate, it says, please, sir, I want you to juxtapose the exclusive jurisdiction of the ISA on Section 84, Section 284, and provisions of Section 251 of the Constitution, which vest exclusive rights on the Federal High Court. Can the aforementioned courts be said to have concurrent jurisdiction on capital market operations in Nigeria? That's from Hyacinth Chubike.
Okay, Hyacinth, thank you so much. One, there's no conflict between the jurisdiction of the Investments and Securities Tribunal as seen under the Investments and Securities Act, number 29 of 2007, and that of the Federal High Court as seen under Section 251, sub 1 of the 1999 Constitution as amended. There's no conflict. There is no mention of capital market matters in the Section 251, sub 1 relating to the Federal High Court. And so what the tribunal handles is what is specifically mentioned as being under institution under the ISA. And interestingly, many judges of the Federal High Court have been transferring capital market matters filed before them to the tribunal. That was how the case of Ajayi and SEC came up. It was transferred from the Federal High Court. So the Federal High Court judges have been invoking the provisions of Section 22, subsection 7 of the Federal High Court Act to transfer matters which they know are not properly filed before them to the appropriate court. So that is the position.
Okay, the next question is from Daniel Okwara. He says, thank you, sir. Please, I need to be cleared. Can the IST enforce their own judgment?
Thank you, Dan. Currently, no. What happens is that after the IST has delivered its judgment, it will register a certified copy of that judgment with the Chief Registrar of the Federal High Court. It is the Federal High Court for now. The IST uses the instrumentality of the Federal High Court to enforce its judgments for now. So, but we are calling for the National Assembly to amend the law so that IST can enforce its judgments directly.
Okay. Thank you. Amefuna Amado says, does the ISA 2007 provide for ADR in respect of capital markets disputes, such as mediation or arbitration?
Okay. Now, there's no specific provision of ADR in the ISA, but like if you look at section rule 600 of SEC rules, yes, which talks about negotiated settlement of a dispute where an errant capital market operator who is facing prosecution or sanction by SEC may suggest to SEC, okay, please, let me pay this in lieu of prosecution, just like a plea bargain. So, but however, the Investments and Securities Tribunal has an ADR department. It's been there since 2008. So it has, and the IST rules also contain provisions on the ADR. We deploy mediation in IST's ADR operations. And so many matters have been resolved. So many non-contentious matters have been resolved in IST via its ADR mechanism.
Thank you. Omoni Onabule says, thank you, sir, for the brilliant presentation. However, in a matter I handled, the primary objection against my client was unsuccessful on the basis that SEC is already aware of the dispute and may not necessarily give a pre-action notice to come before the tribunal. This was in 2017 or so. I do not know if a law has been made against it.
Now, the law is clear that whether it's an originating application or appeal, you must give SEC pre-action notice, even though some of us are of the view that pre-action notice shouldn't apply to appeals against SEC decisions. So I don't know, it seems your question is saying that the objection was unsuccessful because SEC was already aware. Well, I don't know, was it before the tribunal? Because once the matter comes before the tribunal and SEC was not, the tribunal observes that SEC was not giving pre-action notice, the matter is struck out. The matter will be struck out. So this particular one you are talking about, Thomas Kingsley, these are cases that Thomas Kingsley's matter was filed directly by SEC. So SEC will not give pre-action notice to itself. I'm aware of these cases. There were cases, the man was facing, okay, I refer to Thomas Kingsley's case where SEC intervened to sanction an erring capital market operator. So SEC now brought the matter before IST. So in that case, you don't require pre-action notice.
Okay. Ramat Mohammed says, great and incisive presentation. He says, how can banks validly put a freeze on the account of fraudulent capital market operators without a court order in the light of the argument of the delay of justice, contrary to the provisions of the Constitution? Not sure what the question is, but I think maybe just to reiterate on how a freeze can be put on capital markets, fraudulent capital market operators.
Okay. Now, so what certain things, some people take, some persons and institutions take the laws into their hands. Now, I'm not, I know what is possible. It's possible that a bank could put there's not, say no debit this on somebody's account. But that is actionable, except there's a court order to that effect, or maybe they're acting on directive from the CBN. So, but under section 13 subsection X of paragraph S of Investments and Securities Act, the Securities and Exchange Commission is required to seek orders, enforcement orders from the IST before freezing the account of any capital market operator who is accused of one misconduct or the other.
Thank you so much. And as always says, okay, I'm a registered capital markets consultant. How do I register with the CMSA? Please just send an email to cmsanigeria@gmail.com. We will send you the requirements once you are a capital market consultant registered with SEC, and we'll take you from there. I think that brings it to the end of not just this session, but of the webinar. Thank you so much, Mr. Ogo, for taking out time from the very busy schedule. Please do, sir.
Now, regarding the requirements for the registration of lawyers with SEC, I thought there was decision by the Supreme Court also in Professor A.B. Kasumu and SEC, which held that a lawyer ought not to undergo the same registration as other professionals he is practicing as a lawyer, and he has been certified by the law school or by the Council for Legal Institution to do that, so he doesn't need another registration with SEC. Is it being
case dealt with the ISA 1999? And in that petitioners or solicitors, then it means that they were not part of the people captured with respect to registration. However, that lacuna was now overtaken by 2007, which now specifically mentions that legal practitioners who now deal with respect to the capital markets under 180 are now required to register. So in other words, that particular case law had been overtaken by the IAC 2007.
Okay. Then secondly, thank you so much. Secondly, I urge for a downward review of the strict requirements for registration with CMSA. There should be a provision for lawyers who are working with SEC and Investments and Securities Tribunal, not just lawyers in active private practice.
Thank you so much, Mr. We will definitely look at that and see how we can incorporate our colleagues in the IST. I really appreciate you taking out time to share your wealth of knowledge with us. It's really been very educative. From the comments that we've seen, it's been incisive, it's been educative. To everyone who has been with us since the past week, all the slides will be shared. We want to say thank you so much, and we'll definitely let everyone know of the CMSA activities as they proceed. I wish everyone a Merry Christmas in advance, and do enjoy the rest of your week. Thank you so much.
You're welcome.